Welcome to Employment Law This Week. I'm George Whipple. Our top story, a transgender discrimination claim dismissed in a Texas federal court. A transgender employee of L3 Communications filed suit against the company and its health insurance provider after she was denied coverage for breast implants. The implants were deemed medically necessary to treat gender dysphoria by a healthcare professional. The employee alleged discrimination in violation of Section 1557 of the Affordable Care Act, ERISA, and Title VII of the Civil Rights Act. The Texas court dismissed the Section 1557 and ERISA claims, finding that neither includes protections against gender identity discrimination. The judge declined to dismiss the employee's Title VII claims, rejecting the company's arguments that the denial of benefits was not an adverse employment action. Ken Kelly has more.
The question of gender identity discrimination is really up in the forefront of discrimination litigation now. In the Fourth Circuit, there's been a decision called Grimm versus City of Gloucester, which has held that sex discrimination includes gender identity discrimination. And other courts in the Ninth Circuit and the 11th Circuit, I believe, have also come out with the same decision. Here we have a decision which goes the other way around. So the only way this is going to be resolved is for the United States Supreme Court to get all these different decisions and come up with a definitive decision. As a matter of fact, the Grimm case is being argued before the Supreme Court at the end of March. So hopefully, if we have a 9-judge panel, we'll be able to come to a decision nationwide as to whether sex discrimination includes gender identity discrimination.
The Ninth Circuit won't reinstate President Trump's travel ban. Last Thursday, a 3-judge panel unanimously ruled that the executive order which suspended the entry of foreign nationals from 7 mostly Muslim countries should remain blocked while the issue is in litigation. In an ironic twist, the court cited a Fifth Circuit case opposing President Obama's 2014 Dreamers executive action for the nationwide scope of the temporary restraining order and for Minnesota and Washington's standing to bring the case. The Trump administration could appeal to the Supreme Court. Meanwhile, the case is proceeding towards a hearing for preliminary injunction back in the district court. The Third Circuit rules honest belief can defeat an FMLA retaliation claim. An employee was arrested for driving under the influence on the day he had taken leave under the Family and Medical Leave Act. He was subsequently fired and filed an FMLA retaliation claim against his employer. In a presidential opinion, the Third Circuit found that an employer's honest belief that a worker misused FMLA leave is a non-discriminatory justification for termination, whether or not that belief was mistaken. New regulations explaining New York's pay transparency law. In 2015, New York's equal pay law made it illegal for employers to prohibit employees from discussing the wages of other employees. The law does allow employers to implement a written policy limiting those discussions without the other employee's prior permission. The new regulations explain that a coworker's verbal authorization, if given voluntarily and in advance, is sufficient to meet the prior permission requirement. And that brings us to our tip of the week. Maria Van Hees, Edgewell Personal Care's Assistant General Counsel for Labor and Employment, is here with some advice on best practices in developing a beneficial relationship between legal and HR.
To develop a beneficial relationship with human resources, learn about their challenges and their goals. To do this, get involved. Join group HR meetings, train on topics that are of interest to them, and visit their work sites. If you do this, you will foster a good working relationship and you will gain valuable insight on how to best support human resources.
Thanks, Maria. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.